Yo, peace, love, and law, everyone. We give thanks to each and every last one of you that's joining us tonight. Gonna give you guys a little bit of time to tune in, hit the share button, like, share, and subscribe. So we're gonna talk to you guys about something to help you out. Tonight we're going to be speaking on how to enforce equity and stopping foreclosure. First, you have to understand what equity is. What does it mean to be fair? What does it mean to be righteous? What does it mean to be just? Then you have to understand your rights. Know who you are in every situation that you are participating in, for one. Know the rules. And we're going to be speaking on that tonight. So maybe you know someone that's in foreclosure. Maybe you're in foreclosure yourself. But this is definitely for you. So make sure you guys are hitting the share button so we can talk about this tonight. All right, we appreciate you. Guys, as always, man, and I know it's late. I know you guys are flipping and scrolling and doing a little bit of this and a little bit of that. But again, we always give thanks to those of you that tune in with us and lock in with us as well. Like I say, tonight we're going to be talking about foreclosure and how to stop foreclosure and equity. And how do you do this in court and up on the court procedures and things like that? What should you do? A lot of you guys do a lot of things that are just totally wrong, and you have to understand certain things, right? There are certain methods you can do to handle stuff privately outside of court, but today we're going to speak on things of what to do while you're inside of court. All right. What's up, Mr. Simple? How you doing? Seeing you logged in, man. Met your family, so beautiful family for sure. Hey, we didn't get to see you there. Also, man, just give thanks to everybody that has come to the conference, man. The conference was beautiful. Everything was great. Everybody that participated and everything. So it turned out great. I will say that. So we just gonna build some more off of that coming off of the conference and some things as well. So drop your ones if you're with me up in here tonight. Let me know where y'all from, where y'all connecting with us from tonight so we can lock in with you. As again, I always say, man, if you know somebody that is in need of this information, hit the share button right now. Right now. All right. Before we move forward, though, everything that you hear is going to be for educational, religious purposes only. So anybody seeking any type of legal advice, go and see a legal advisor, as it is my religious duty to speak my religious truth. Funky Town, Funky Town, Texas. What's up? Massachusetts in the house. That's what's up. Massachusetts. That's the first time I ever heard. Had to say that on here. Or I haven't seen it to pay attention to say it. But we definitely welcome you in here with us tonight and hope that you guys learn something no matter where you at this moment, right? That's what we on. So what we gonna put y'all on today? All right, so let's talk about it. Mississippi, what's up, Mississippi? Mississippi in the house too. Next door neighbor, right here in Alabama. But let's talk about it though. So when it comes down to you guys foreclosures, stuff like that, there are certain things that has to take place when it comes to this promissory note negotiable instrument and the right to actually enforce the instrument. Okay. And I don't care if it's a non-judicial foreclosure state or whatever. If you just listen, you're gonna understand something and learn something tonight. Okay? Because it doesn't matter. There's nothing that supersedes your constitutional rights. So anytime they do a non-judicial foreclosure and they do that and they seize your property without due process, you might want to think about that before you let a state consider itself non-judicial by legislative laws and something that infringes upon constitutional rights. So y'all might want to start checking yourself when y'all be allowing that to happen. That's why it's very important to understand that our base foundation of everything is the supreme law of the land when it comes to dealing with this corporation and these, when I say corporations, the United States and any other corporations as well. And that's why it's very important to understand that contract is afforded to you in equity, and all officers of it must fully perform to protect you in that. So that means that if a corporation is operating outside of its capacity and it was chartered, then it can lose its charter by, doing usurping powers that it don't have, or was given the privilege to do as well as other things, right? So all of this is gonna work in our favor. So we're gonna have to speak on this tonight, right? So share, come on, let's go. Hit the share button, show some love. All right, so. But when it comes down to this, like there are certain things that happens when it comes to negotiable instruments and stuff like that. So when it comes to negotiable instruments, you guys have to realize that there has to be a holder in due course, okay? And under the holder in due course, stuff of things of that nature, right? And let me help you identify what I mean by the actual holder in due course, right? What is the holder in due course here? So if we go to UCC 3-301. All right. Again, that is UCC-3-301. All right. So when you come to this, right, this is what you're going to see. Person entitled to enforce an instrument means the holder of the instrument. Keyword, holder, because the holder is always the what? In bearer form. And that's why you can only assume somebody owns something because they are the one who holds it. Until they say, hey, I don't own this, or somebody else shows up with a form of specific right, interest, or something transferred to them by title or something of that nature, right? So a non-holder in possession of the instrument who has the rights of a holder. So that means a non-holder in possession of the instrument, all right, who has the rights of a holder. Okay, so a person not in possession of the instrument who is entitled to enforce the instrument pursuant to section 3-309 or 314D, which we will go to in a second. And a person may be a person entitled to enforce the instrument, even though the person is not the owner of the instrument or is in wrongful possession of the instrument, right? So let's go look at what this one say. 3-14D right here. Notwithstanding section 4112, if an instrument is paid or accepted by mistake and the payer or acceptor recovers payment or revokes acceptance, the instrument is deemed not to have been paid or accepted and is treated as dishonored, and the person from whom the payment is recovered has rights as a person entitled to enforce the dishonored instrument. So, again, payment or acceptance by mistake. Keep that in mind when you start talking about the person entitled to enforce. Okay? So the person that is entitled to the force is the holder. The holder has to have it. And then if they don't actually have it, then they have to be able to show full proof of chain of title to where it was given. And they not gonna ever have that. It's kind of hard. It defeats the purpose to actually have that. So, then you got enforcement of loss. So if it's under this, a person not in possession of an instrument is entitled to enforce the instrument if the person seeking to enforce the instrument was entitled to enforce it. The instrument, when loss or of possession occurred, or has directly or indirectly acquired ownership of the instrument from a person who was entitled to enforce the instrument when loss of possession occurred. The loss of possession was not the result of a transfer by the person or lawful seizure, and the person cannot reasonably obtain possession of the instrument because the instrument was destroyed. Its whereabouts cannot be determined, or it is in the wrongful possession of an unknown person or person that cannot be found, or is not amenable to serve as a process. So a person seeking enforcement of an instrument under subsection A must prove the terms of the instrument and the person's right to enforce the instrument. Okay, if that proof is made, section 3-308 applies to the case as if the person seeking enforcement had produced the instrument. The court may not enter judgment in favor of the person seeking enforcement unless it finds that the person required to pay the instrument is adequately protected against the loss that might occur by reason of claim by another person to enforce the instrument. Adequate protection may be provided by any reasonable means. So what they basically saying is like, if it's lost or whatever, and this person's making the claim with you, et cetera, the only way the judge can make a form of judgment on it is that nobody else can come ever, even if they wasn't the one to ever hold it. So you got to make sure that is right as well. No, the holder can be a fictional entity because it could be any form of entity. So we don't need to go there because even your entity that you're dealing with to sue in their courts is fiction. A living man cannot go sue in these courts today. Not like that. Because you're having to use the entity in order to speak with the actual United States because they're fully operated in commerce now. So you got to understand that part. All right, so now that you see what they're saying here to you, you have to understand this. All right. So now they have to be the person entitled to enforce it. All right. If they are considered a non-holder in possession of the instrument who has the rights of a holder, then that means they got to show chain of title, proof that something was given to them, and maybe the instrument is being held somewhere else, etc. But all of that has to be in full discovery of, right? And if not, if it's not disclosed to you, then there you go. Because everything has to be fully disclosed to you. Now, that's something that they also have to answer to. So now that we know, in order to enforce an instrument, a negotiable instrument, you have to have the actual note. Well, here's the thing, guys. In mortgages, there's something that happens. Okay? So in mortgages, the note separates. Okay? The note end up separating from the deed and title. Okay? See, a lot of people try to make these claims because they'll try to claim interest in the deed or title, but they can't do the note because the note is always going into a pool of service agreement to where it goes into an asset-backed securities. So once it goes into that, that's a real estate, like an investment trust. So it'll never come out. Okay? It ain't coming out. So just so you understand that part. All right. So, but once that happens, though, once they separate the note and the deed of title, then it's no longer considered negotiable because you're not transferring the whole, what made the negotiation itself. You can't separate the actual security interest in the note at the same time, right? You Can't do that. And if you do, it is considered to under UCC 3-604. It's discharged. So a person entitled to enforce an instrument with or without consideration, may discharge the obligation of a party to pay the instrument by an intentional voluntary act. Okay? By an intentional voluntary act, such as surrender of the instrument to the party. So listen, guys, if they ever, this is why you will never find or never get the original instrument when they say, oh, I want the original birth certificate. You're not going to get any of that. Because if they surrender it, it is considered to be a automatically discharged, whether it was with or without consideration. Doesn't matter. But what happens here is it's destroyed. It's a form of destruction because it's no longer considered negotiable because you separated the actual, the deed of title from the actual note. Those two have to be transferred together. They cannot be transferred separately. And that is the only way that you're fully going to actually be able to enforce or for them to enforce it, just so you guys can know. Okay? So now that is automatically what happens. Discharged. All right? The separation of the note and the deed of title. Discharge. To hold the deed of title, which is actually showing where the lien is, but they also supposed to perfect that on a UCC 9, which they don't. But they supposed to perfect that on a UCC 1 by Article 9, So when they do that, which they don't, but if they was supposed to do that, then again, see, they only have the secured interest. The note is gone in the deed of title. And the deed of title is what's stating that there's a lien on the property. All right. So if the deed of title is stating that the particular entity holds the lien, then they also have to have the actual note to enforce the lien. Okay. Because if they don't have the note, then they don't have the right to enforce the lien. Okay. And if all they got is the lien, then they can't foreclose based upon non-payment because they don't have the note. Drop some ones if you understand what I'm saying. Can't do one without the other. Can't foreclose for non-payment without the note. And if they wasn't transferred the deed of title in the correct manner, then they don't have the right to seek any secured interest into the actual house from a deed of title with the lien on it because it was never transferred properly. So if neither one of them came together, then they are lacking some form of authority and standing here. All right? So now, here's the thing. How did this work in court? Because most of you think that, okay, I'm going to do an affidavit, right? And if I do an affidavit, I'm going to mention that I asked this particular party to show me this particular note and et cetera, and they didn't do it, and this is my affidavit. Well, listen, guys, affidavit of truth is just considered evidence. I'm going to say this again. Affidavit of truths are considered a form of facts that can be presented as evidence. That's all. It does not compel the court to do anything. Okay? Now, which is also why you can be called to the witness stand as well, based upon your affidavit of truth and of the facts that were stated. Now, not only that, you got to understand that the affidavit does not do anything because now you need a motion to admit the evidence to be heard, which is the affidavit. Now, that is what allows your affidavit to be heard. You see what I'm saying? So in order for the affidavit to be heard, we need to compel the court to hear it by motion. The court has to be moved at all times, which is equity. Equity demands performance. So as the people, what performance are we looking for to be in equity here, to be performed? Let me know. We're looking in the chat. What performance are we looking for that compels the court to perform on your behalf? You said specific performance, but why? But from what? From what? Please explain to me. From what? No. See, this is where you guys messed up at already. I keep saying the base foundation is the Constitution. The first thing that you want afforded input and equity to you and to always be performed is the Constitution. No matter what. The court is built and created from the Constitution. The officers in the court have to honor the Constitution. That is the preceded contract. So before we start talking about this contract that the plaintiff is talking about, first we need to make sure we understand our contract, which is the Constitution. So now we need due process to be fully upheld in the court today in all equitable favor to the people, which is yourself. So we can make sure that corporations are not being able to come in and take the people's property based upon these type of legislative things, which is what they built them for. They built banks and everything to do what they're doing to be able to step in these courtrooms by legislations and take from you. I hope y'all know that. Because once it gets to court, if you don't understand the proceeding and what to do, whether they're right or wrong, doesn't matter. What matters is you didn't understand the procedure and how to obtain the remedy that you sought or were looking for, or you don't have the money to pay a lawyer to seek what you're looking for. Right? That's usually what it is. That's what it boils down to, correct? So since we know that it boils down to that, now we have to just all right, well, let's just figure out how do we change this? And the only way we're going to change this is become knowledgeable ourselves. All right, so again, the first thing that you have to understand to do when it comes to these courts is you got to know how to move, right? So the first thing that we want to always do is we want to do a motion because we're going to do this. See, you can give a full answer first and foremost, okay, saying you do not recall. And that's what it would best be and best to do, because we're not here to say yes or no. We just don't recall. Okay? So saying yes and no causes an argumentative statement. So we're not saying yes and we're not saying no, because even to say no, it still means that we are answering to the contract. So what we're going to do is I have no knowledge of. Okay? So everything that they're saying is I have no knowledge of, or I can't recall, I can't remember. And the reason why we do this is specifically because now they have to prove it. I can't recall. I'm going to need further evidence to show proof, to provide, right? Okay? I'm going to need more evidence. And we're going to continue to say that on every little point they made. Oh, they said you signed on this day? Well, I can't recall. I need further evidence provided as proof for me today. Do y'all understand what I'm saying? Because now we're not saying that there is a contract to exist because as soon as you say the contract exists, what happens is the judge start looking like, okay, so there is a contract. You admit to there being a contract, and since you know there was a contract, you also admitting that you were supposed to make payment. Why didn't you make payment? See, now we can't admit that there's a contract at this point. We can't say any of that. I do not recall. I have no knowledge of. I'm going to need further proof. You see what I'm saying? Give me further proof here. Because otherwise, I don't understand. I don't see. I don't know. Right? So that's why we got to ask for further proof. And then in that further proof, we can commit. Now, after we gave our answer and saying what we were saying, now we're going to send in a motion to compel discovery of the original note because we need further proof. Now, you have to do a motion. I don't care whatever you want to do. If you need the court to do anything, equity is motion. Motion is looking for a performance, something to happen that you need to happen. So that is what you consider equity. If we do a motion to dismiss is a sign of equity because someone doesn't have a cause of reaction. So what does equity mean? Do what is fair. So the case need to be dismissed because they failed to state a cause of action to grant relief, which is equity. All right? Drop some ones if you understand right now. Let me know y'all understand what we saying right now. Because this is what makes everything different. Right? All right, so comes now to John H. Doe, the defendant in the above captured matter, and respectfully move this honorable court to compel the plaintiff to produce the original promissory note associated with the claim in this case. This motion is made to ensure compliance with Alabama Uniform Commercial Code and due process principles, which require that the plaintiff demonstrate its standing and authority to enforce a negotiable instrument. So look, we need them to do what? I want y'all to listen to what we're saying here. All right? We need them to do this because this is for due process principles. Because they need to show what? Full proof, evidence. Because right now, the first thing they want you to do is admitting to the statements that they're in. I don't recall. You see what I'm saying? I don't know. I can't remember. And the court wasn't there. None of the people in the court was there. And if I don't know, and if I don't admit to it in any kind of way by saying yes or no, then now they have to produce. See, because if I say no, now that means I have to prove that there was no contract that I did. I have to give an out. Oh, well, no, I didn't sign a contract, et cetera. I was here, da, da, da. You know what I'm saying? But if I just strictly just say I have no knowledge of, now that puts all the burden on them to give us more further knowledge of proof, right? So now, as you can see, it's still 3-301. It's still the same, but it was adopted under Article 7 here, Chapter 7, I guess, under the UCC, so in Alabama. So only the holder in due course defined as the party in physical possession of the original note with the right to enforce it may initiate an action based on a negotiable instrument here. All right. So the original note serve as prima facie evidence of the plaintiff's authority and is essential to establish standing. So we need that. J.P. Morgan Chase Bank versus Mantle. So importance of the original note. Without the original note, the plaintiff cannot substantiate its claim or prove its right to enforce the debt. A copy is insufficient to meet the burden of proof under Alabama Code 7-3-309, enforcement of lost, destroyed, or stolen instrument. So, again, they got to come up forward. Relevant case law, such as the U.S. Bank National Association versus Albanese, established that a party seeking enforcement of a note must possess the original note and demonstrate clear ownership. Chain of title must be established. See, that's what I was telling you earlier. So to enforce a negotiable instrument, the plaintiff must provide an unbroken chain of title documenting its ownership and from the original lender to the current holder. All right, as affirmed in the Dutch Bank, Lykenfels in Ohio in 2013. So now this is what hits them. Rule 26B1. This is why the court is going to have to do this, because this starts dealing with the Constitution Under Rule 26B1 of the Alabama Rules of Civil Procedure, the defendant is entitled to discovery of materials relevant to the plaintiff's claim, including the original promissory note and all assignments or endorsements. We got it. We got the right to see it. And if you want to put in there the securitization audit, you got the right to know anything that has happened to the note. You see what I'm saying? No matter what, anything else that you guys want to add in here, you do. But that's just what I'm saying. But in order to do this, because a lot of people just put on there and answer an affidavit and that's it. You just gave an answer. And giving the answer is not enough. Behind the answer should come what you compel the court to do, especially if you in defense. So if you in defense with your answer, then it should be followed by a way to motion the court. I answer, and now I'm going to move the court based on my answer. Drop some ones if you understand what I'm saying. Gonna do a little vibe check right now, man. Make sure y'all hit the button. Get showing some love up in here. Before I show you what's next, hit the share button as well. Let's go. Show some love, man. I think y'all can get us up, man. Get us up to 5,000 on we ought to be up. We ought to at least get 10,000 a night with this type of information we dropping to y'all. Let's go, TikTok. Keep it going, man. For those of you that on TikTok, man, remember you can log in with us on YouTube, In God We Trust Academy. That's where you can catch all of the past lives as well. So that it does save on there for you guys. So you can go watch them there. So again, follow us on In God We Trust Academy on Twitch and as well as YouTube, Facebook. Follow me, Eric Ingram Bay. And, of course, if you're already here with us on TikTok as well, it's MNRP6192020. So make sure. So let's do this. All right. Let's do this. All right. So now that we got this part out the way, so now let's say they answer, they don't do something, they never show proof of this note, etc., right? So the next thing we should do is we have to do a motion to dismiss. So now they didn't show it. They made a reply, and let's say the note is not there at all. Then your next answer or your next thing to do should be motion to dismiss immediately. And this is the reason why. So comes now yourself, John H. Doe, respectfully moves the honorable court to dismiss the plaintiff's complaint for lack of standing. The plaintiff has failed to produce the original wet ink signed promissory note, which is required under Alabama law and the Uniform Commercial Code to establish standing and enforce a negotiable instrument. As such, this foreclosure action cannot lawfully proceed. The plaintiff initiated foreclosure proceedings against the defendant, alleging default under the terms of a promissory note and mortgage agreement. The defendant filed a timely response demanding that the plaintiff produce the original wet ink signed promissory note to verify its standing and legal right to enforce the instrument. To date, the plaintiff was failed to produce the original promissory note or provide evidence of an unbroken chain of title demonstrating its lawful ownership or possession of the note. Without the original note or evidence of standing, the plaintiff had no legal authority to foreclose on the property. All right. So standing in this threshold is Alabama Code 7-3-301. Only the holder in due course or non-holder in possession with rights of a holder may enforce a negotiable instrument, which means they have to prove chain of title. So the plaintiff's failure to produce the original note demonstrates a lack of standing, as it cannot prove it is the rightful party entitled to enforce the instrument, and the mortgage follows the note. So the mortgage follows the note. So in Carpenter versus Longen in 1872, the U.S. Supreme Court held that the mortgage is inseparable from the note. Without the note, there is no enforceable mortgage. Failure to meet burden of proof. The plaintiff bears the burden of establishing its standing up to foreclose, right? This includes possession of the original note and proof of an unbroken chain of title. It's got to be proved. Got to be proved. Okay? Yeah, this can be used for any type of note. Anybody, and the note is anytime somebody's trying to say that you enter into a contract based on some promise to pay for some form of services, etc., right? So, U.S. Bank National Association, Ibanez 2011, the court invalidated a foreclosure where the foreclosing party could not demonstrate, the ownership of the note. So now we have the right. This would be violation of due process, right? Proceeding without evidence. If they continue to proceed without evidence standing, violates the defendant due process right under the 5th and 14th. Now, this is where the judge has to fully protect, because he understands that evidence is a part of due process. And if that evidence is not fully produced to state a cause of action to grant relief, then they cannot seize the rights through due process, right? They cannot issue a court order because there was no evidence that was entered to show proof. All evidence have to be heard. That's why there are hearings, to hear the evidence, to hear the facts that is being presented. Okay? So understand that part, right? Wherefore the defendant respectfully requests that this honorable court dismiss the complaint and award costs and fees and grant further relief. Boom. It is done in that manner. And then from that point on, that's where we're having to deal with the actual situation of, making sure we uphold everything accordingly. Now, you can also add memorandums to it as well that will also help you in proving your case, which also they know they have to follow. But again, all of this go back to this. So listen, y'all keep saying if we had no hearing at all, if you didn't do this, or if it's a non-judicial state, that's why you have to learn to go do an injunction. Right? If you in a non-judicial state, you must go do an injunction, because the reason why is the Constitution says that in order for them to seize property from you, you have to go through due process of law. And due process of law means that there ends up having to be a form of a jury trial and things of that nature, right? So if you're in a situation that you're not having to go to trial and it was taken through you through a non-judicial proceeding, that is a violation of due process of law that is fully afforded to you. So that's the reason why I say immediately go do an injunction, because one, property was seized from you. And in order to stop the seizing of that property correctly, you need to compel this into the plaintiff, or the defendant, because you're the one going to do a civil claim here, through an injunction. So you compel them to literally have to bring the actual note forward in order to go on with their non-judicial procedure. Otherwise, this would be a violation of due process. So I hope y'all guys understand that as well. And all of this goes back to you knowing who you are in relations to your rights of the Constitution. That's it. And if you think the Constitution and injunctions don't work, well, that's the reason why you're not having the part to report the beneficial of interest anymore, because of it violated the Constitution. Somebody did a what? Injunction. They checked that shit at the door because it's going to violate it. Equity, and now this is another thing too. If you want equity to be done, you got to do equity yourself. But in order to do equity, you have to understand what is fair and just. Which the only way to know that is to understand what is right, what's right. But if you don't know the law, then you can't understand what's right. It's not possible for you to know. It's not possible for you to know. So I just showed you guys, but If anybody just happens to be interested, then you can go to ingodwetrustacademy.com. And when you go to ingodwetrustacademy.com, you can come. What I want y'all to do is go to the search bar, put in private. It'll come straight up for you. Private administration. Click on the one that says live stream here. And all you got to do, if you want what I just showed you today and more, because you got to get a whole lot more, okay? You will definitely get all of these documents that you're able to see right now on your screen, okay? Just so you know that. So that's child support motion to for tax, motion to dismiss for right to travel, motion for court of equity, injunction, stop foreclosure, what I was just telling you about. Notice of religious land, all of this comes in there. So that's a lot. But I'm just speaking on to you for what I just specifically showed you. That is also where you can find this document at. So it's going to go. We already did the conference, so the conference was great, but it's only going to stay at this price for the rest of this week. And after that, I'm going to change it. But I just told you and showed you what to do. So you just need to start familiarizing yourself with everything. All right. So do we got any questions? Anybody want to come forward? Come forth and ask a question. Is there anybody that want to come forth and ask a question? We got the multi-guest on here with us today. I just want to see what y'all got to say. Website name again, ingodwetrustacademy.com. And you can come here. You sure can. So yeah, man, I just really want y'all to know, like, is learn them rates. No, stop feeling like you defeated because you're not. Should you file an injunction if you want to initiate the process and not wait for the default? I would. That's how you stop it. You do injunctions to either stop something from happening or stop something that has happening, and then for them to continue forward with it happening to you. You see what I'm saying? That's why you doing injunctions. Injunctions is the same thing as like a restraining order. So you do those in immediately. As for their own lawyer fees and remedy, I don't know. I'd probably be asking for more because it took me more time to read, study, to do all type of things. No, you're wrong, Aunt. You're totally wrong. You need to go read what injunction is, and then you need to go read why are you doing motions. That'll help you out. Excuse me. Let me see. What was I looking for? It ain't popping up for me. But like, see, an injunction is just like, okay, let's say for instance, I'm aware that they're sending me notices of that they're trying to foreclose on me. I'm finna go do an injunction. So since this is what you want to do, you're making your threats already. So before we even get to you doing your whole full process, let's just bring this shit on up in the court and then make you bring that original note that you got to show prima facie evidence of. I'm going to beat you to the punch because if they take it to court, the only thing they need to prove is that a contract existed. So that's by you saying yeah or no. And it's like, okay, if you say yeah, then that means contract exists. If you say no, then you have to prove it don't exist. Right? So now all you need to do is just don't recall. I have no knowledge of. Can you remind me by showing me proof? No, I didn't say don't file motions. I said know when to file them. Know when to do what you're doing is what my whole entire point is. Don't take nothing for what I'm saying. Go read it. Go study what emotion is and how emotions and what are emotions and when did even emotions come into play, because motions came into play is for equitable reasons to move the court. And a court of equity is an appeal court as well. You can do motions at all times. Oh my God, y'all do not understand, boy. I swear. Why? Well, why motion and not petition? I tell you what, I know what boy is like. I guess that's what you're saying. Well, this is what you're saying. You said why motion and not petition. So that means if they already got you in court and you don't make a motion, you finna lose. You gonna lose immediately. That's my whole entire point. If they already got you in court and you're supposed to be answering or dealing with what's going on as a defendant and you don't make a motion to do something, right? And first you got to give an answer. So you can answer to them by saying certain things you don't recall. And since you don't recall, now you need a motion of discovery to compel them to bring forth what you want. No, but I'm just saying, like that's what a motion would ever be for. Is because you are already in court. That's my whole entire point. We in court. Got you. Now, when it comes to evictions, let me say this to y'all. Yes, injunction works for evictions, but evictions is this. See, none of y'all go. See, the thing about evictions is one simple thing. Y'all always gonna answer yes that you live there and you want to protect it. So now they have a contract anyway. So that's the main thing. In order for you to fully fight an eviction, I keep telling you, what does the rules of the contract say? And what are the obligations? Did they fulfill all obligations to be paid full service by you? And if they haven't, that is the standing that you have when it comes to those type of things. And they don't. Most of them are outdated in their buildings. A lot of them are a lot of stuff I could go on about. Never received discovery request and request settlement closure, no trial. So why you ain't suing? You should be doing an immediate injunction on that because their due process of law wasn't given to you. That's what you have to do. So I just wanted to help you guys out with this tonight, man. Hopefully this furthers your knowledge into this. But if you're looking for what we just did tonight in this, then make sure you go there to receive this. All right. This is my time for the night. So I'm about to roll up out of here. I will see you guys first thing in the AM to rock with you guys. Peace, love, and love. We out of here.